Hi, I'm Evan Oftedal, a teacher at Watchung Hills Regional High School in New Jersey, and this video is about Abraham Lincoln and Habeas Corpus, arguably the most controversial part of his presidency and probably the biggest violation of civil liberties that occurred during the Civil War. And rather than going over a huge overview of the suspension of habeas corpus, we're going to focus on four specific examples. The first is the arrest of John Merriman, the court case that corresponded to that arrest, ex parte Merriman, the arrest of a man named Clement Vallandigham, and finally the Supreme Court case ex parte Milligan. And as we go into these four things, there are three questions you need to ask. One, where did most of these arrests take place? Two, what exactly, what was the context under these arrests took place? And three, if this was a temporary measure, does that excuse some of the controversy surrounding it? And before we even go into our examples, and after we gave our things you should look for, there's some context things we need to go over. First is, secession created a problem in Washington, D.C., because if Maryland seceded, then Washington, D.C. would be surrounded by the Confederacy, and there's a good chance that the federal government would have to flee. And for Abraham Lincoln, that was not an option. The second thing you should consider is there were people in Maryland, as well as elected officials, who were encouraging the destruction of railroad bridges and the cutting of telegraph wires in order to stop the movement of troops through the state. Now, when they cut those telegraph wires, it left Washington, D.C. in the dark. They were completely out of contact for almost a week in April of 1861. You should also consider the fact that Congress isn't around. They're not in session. They're not going to return until the 4th of July, and that was only after Lincoln called an emergency session. So legislatively, there's nothing they can really do. So Lincoln's stuck on his own to fight a war and stops the spread of secession. The last thing to consider is the fact that violence had broken out, and Lincoln himself, despite that violence, hesitated to suspend habeas corpus. But when he did, he was very, very narrow about it. He only suspended it between Philadelphia and Baltimore, wherever the troops were moving. And that led us to our first example, Mr. Merriman. John Merriman was a farmer outside Baltimore. He was very wealthy, pretty well known, and he was one of those people that was involved in the destruction of railroad bridges as well as the, cutting of telegraph wires. And he also recruited Confederate soldiers in Maryland, which created a bit of a problem. He didn't like Lincoln, he didn't like the policies of the war, and he was very much a Confederate sympathizer. So on May 25th, he was arrested early in the morning and imprisoned in Fort McHenry in Baltimore without giving a charge by the military. He's not officially a member of the military, so consider that. And his case garnered some attention because of his prominence. And the Chief Justice of the Supreme Court at the time, a guy named Roger Taney, was from Maryland. And in addition to being the Chief Justice, he was also a circuit judge in Maryland. And while riding circuit, he asked for a writ of habeas corpus for Mr. Merriman, which means I need to talk to him and at least know what's going on. He was denied this, and Taney was furious because he couldn't believe that the military and the executive branch as a whole would do such a thing as suspend the writ of habeas corpus. So he gave a very famous answer known as ex parte Merriman, which is our second example. And here's what he said in that case. And these great and fundamental laws, which Congress itself could not suspend, have been disregarded and suspended, like the writ of habeas corpus, by a military order supported by force of arms. The people of the United States are no longer living under the government of laws, but every citizen holds life, liberty, and property at the will and pleasure of a military officer in the military district he may be found. So Lincoln finds himself in a showdown between himself and the Chief Justice of the Supreme Court. I wonder who's going to win. So Congress comes back, and of course they have all kinds of questions for Lincoln, and Lincoln's got an answer for him. Must they be allowed to finally fail of execution, talk about all the laws, even if it had been perfectly clear that by the use of means necessary to their execution, some single law, habeas corpus, may be in such extreme tenderness in citizens' liberty that practically it relieves more of the guilty than of the innocent, should to a very limited extent be violated? To state the question more directly, are all the laws but one to go unexecuted and the government itself go to pieces, lest that one be violated? How did Congress respond? They didn't do anything. They let him get away with it. And Lincoln in 1862 expands it to include the entire Union, not just the border states and not just the Confederacy. And Congress themselves finally enact the Habeas Corpus Act in May of 1863. If there's an arrest that gained the most controversy for Lincoln, it was the arrest of Clement Vallandigham in May of 1863. Vallandigham was an outspoken leader of the Peace Democrats, or Copperheads. He lived in Ohio, so he's not living in a border state. He's not living in an area where the war is taking place. However, he was a very, very outspoken critic of Lincoln, the war, emancipation, the draft, and just about everything Lincoln tried to do. But does that constitute the need to be arrested by the military? That's the question being asked here. So Vallandigham's arrest created outrage, created a firestorm of controversy, and Lincoln himself was, well, forced to give an answer to his critics. So he did so about a month and a half later in the very famous Corning letter. He was not arrested because Vallandigham, he was not arrested because he was damaging the political prospects of the administration or the personal interests of the commanding general, but because he was damaging the army, upon the existence and vigor of which the life of the nation depends. He was warring upon the military, and this gave the military constitutional jurisdiction to lay hands upon him. Vallandigham is one of 13,000 up to 30,000 people who were arrested without habeas corpus or by the military during the course of the Civil War. But he's one of the unique cases where it wasn't a deserter, it wasn't a violent criminal, it wasn't someone evading the draft, it wasn't someone doing something violent against the government. He was a political opponent. Vallandigham was released, he was banished to the Confederacy, fled to Canada, and then came back and was obscured. So that's the thing that's important. Most of the arrests took place in the border states or the Confederacy, not in the northern states like Ohio or, in our last case, Indiana, in the case of Milligan. So when the war's over in 1866, the Supreme Court finally issues a decision based, what is the legitimacy of these actions? And they picked a particular case involving a man named Lambton Milligan, who was an active secessionist in Indiana. Now, Indiana, just like Ohio, in Vallandigham's case, was not involved in the war. There was no war going on, but it was still under somewhat military jurisdiction, as was most cases in the North. And so he was arrested and sentenced to death for treason. And he claimed that he should have been tried in a civilian court because there were civilian courts operating. So the Supreme Court, almost 2 years after the fact he gets arrested in 1864, decides to make a decision. And here's what they had to say. A citizen not connected with military service and a resident in a state where the courts are open and in the proper exercise of or their jurisdiction cannot, even when the privilege of habeas corpus is suspended, be tried, convicted, or sentenced otherwise than by the ordinary courts of law. This decision obviously overturned many of Lincoln's policies regarding civil liberties. And it's important to note that the decision has become a benchmark in terms of the protection of civil liberties across all wide area of issues. Most recently, it's been used in the defense of foreign terrorists in their interrogations by the United States government. At the same time, though, it's important to understand that this provides a nice bookend to the beginning where the consequences were extreme in 1861, and looking back in 1866, they could see that, okay, this was a temporary situation, but we got to try to make sure that something like this does not happen again. In doing so, I hope that you've taken the time to think about those things we've discussed during the video, namely where the arrest took place, who was arrested, and also, well, the temporary nature of these arrests. Was this a special circumstance? Thank you for watching.